Mrs. Champagne never had a job when we were married. So any lines of credit, any loans, all the properties, those were all in my name, Your Honor. So when you say you don't have time, and that's what's aggravating me the most,
Mr. Champagne, this is a motion hearing. Do you want a trial date?
I need you to understand what's going on, not what they want you to believe. So when you have time to read the case file.
The record, this matter is before the court on the plaintiff's motion for judgment against defendant for failure to pay a debt to Directions Credit Union. The parties have conferred this morning with Mr. Pratt, who has provided the court the final recommendation that the defendant, Wayne Champagne, shall pay to plaintiff Laurie Champagne $15,000 that was paid by the plaintiff out of the recent closing on the Monona property, Monona Drive property. And he shall also be responsible to pay the balance of a loan that's been added as a lien on the Scott Street property of $4,915.53. That's relief you're requesting, Ms. Rosekolviak. Is that correct?
It is, Your Honor.
Right, Mr. Champagne, your response?
Yeah, I disagree with Mrs. LaPrade. She kind of, one time she said she couldn't see it in the divorce decree, and it was never in the divorce decree. They violated the first court order that she wants to say that judgment was added to there, and it was not.
All right, so you disagree with the recommendation, Mr. Champagne. So the court has a number of questions. First of all, this case is a mess. I mean, it's been piecemeal together.
Well,
where in the judgment of divorce or stipulated orders, Ms. Rosekolviak, is this Directions Credit Union loan addressed? See anywhere?
It is not, Your Honor, because of, as you said, we had quite a struggle to get it
all.
all.
In whose name was this debt? Is it Mr. Champagne's name only?
Mr. Champagne's name only.
Okay, and why? How did was there not discovery during the course of this divorce they didn't know about? Champagne did not know about this debt?
Number one, we did not know about the debt until after, if you look at the timeline, there is a stipulated order from May 7th of 2021, where my client was awarded the Monona property and the Scott Street property. And then there was also a final decree of divorce, which was entered.
Yeah, I've looked at the judgment. I've looked at stipulated orders where the stipulated order of May 5th specifically awards Monona property to the plaintiff, and she shall refinance any debt thereon. Was this debt to Directions Credit Union was ever secured by a mortgage on any property?
It was put on the property after it was given to her.
Understood. When the loan was taken out by Mr. Champagne, was it ever secured by a mortgage, or was this an unsecured debt?
No.
This was unsecured debt?
Correct.
Okay, and so neither you nor your office or Mr. Chaplin or Ms. Champagne knew about this debt until the judgment lien came to surface in 2024. Is that correct?
When the judgment lien came into place, yes.
Right, and this debt was only Mr. Champagne's name?
That is correct.
And obviously the court understands the time frame. The property Monroe Drive was quitclaimed by Mr. Champagne to Ms. Champagne in December of 2022. The judgment lien was recorded 3 months prior thereto in September of 2022. So obviously the judgment lien attached to the Monroe property because it was the name of Mr. Champagne prior to the quitclaim transfer. Is that correct?
That is correct. That's my understanding.
All right. So I guess we need to reopen this divorce case and then determine who's responsible for that $19,000 loan. I mean, is it a marital debt? Is it a debt, business debt of Mr. Champagne? I guess we need to have a trial on that. We need to reopen this divorce case. It's not addressing the judgment. It was an issue that no one knew about.
Well, Your Honor, I would argue that the fact that she was supposed to get the Monona property free and clear of any debt.
Well, hold on. No, it said she should refinance the debt thereon. Didn't say it was free and clear.
That was debt thereon at the time that it was transferred, that it was given to her. That was subsequently put on to, the debt was put on there after it was, after it was granted to her.
Understood. All right.
But Your Honor,
Mr. Champagne, you had attorneys throughout this divorce action, and your attorneys should have disclosed that. Wasn't there discovery, Ms. Rosekolviak, when they're interrogatories where people have disclosed debts?
There was, Your Honor, and I would say, as I said before, because of the piecemeal nature of this, if you will look at, I don't remember what exhibit is, but it goes to all the property that the parties distributed. And I'll tell you what happened. On the stipulated order that was signed on March 5th of 2021, they distributed various property with the husband getting a Chevy pickup truck, a Harley, a Suzuki, a rat rod, and those had various items of debt on them. And if you'll notice, we put them as an agreed value of 0 with the idea that Mr. Champagne was going to take the debt that was associated with those items. So it's our argument that even though the debts were not specifically allocated in the judgment entry, they were taken into account when we distributed certain property. So I understand it is not clear as it should be, but I think that was the understanding when we came to those, because obviously I can go back, the Harley did not have a value of 0. It had a value of $27,000 or something, and then there was a $27,000 debt that was associated with it.
Your Honor, if I could say,
Mr. Champagne, what was this debt obtained for? What did you do with the $19,000, the debt? Did you buy a Harley with it?
no, I don't know why they got, I hate the word meal piece. It sounds so unprofessional. The meal
Mr.
piece.
Champagne, this is not a trial. I don't have all morning. I've got cases every 15 to 30
Well,
minutes.
let's settle it. Let's settle it when you have, I think we should settle when we have time. That's the
Mr.
second time
Champagne?
you told me that you don't have time for me. And
Mr. Champagne, I'm just answer the question, please. I'm trying to focus in, your mind. What was this debt obtained for? Did you buy a motorcycle with it? Did you make home improvements with it?
No, Your Honor, it was a marital debt prior to our divorce. It was a line of credit.
Okay, well, we need some information about that. That was only your name. You say it's a marital debt. Why wasn't it discussed by your attorneys at the time of the divorce? If you claim it's a marital debt, it appears on the surface to be your debt alone.
That's correct, but Mr. Champagne never had a job when we were married. So any lines of credit, any loans, all the properties, those were all in my name, Your Honor. So if you looked at it on the surface, it would be all my debt. But we know during the divorce, and I've learned that if the debt occurs during the marriage, it's the marital debt. So
get back to the question the court asked, Mr. Champagne. What was the loan secured for at the time?
Help paying the payments. When Mr. Champagne left, I was using the line of credit. I had another line of credit at the credit union. Sometimes my checks wasn't enough to pay the bills. I have to take a few hundred out here to pay for, the gas, the utilities, buy things for my girls. There was a $7,000 side-by-side purchase from the Directions Credit Union. That was a gift given to Mr. Champagne's nieces and nephews that we were raising. They were foster children of ours. They destroyed the machine. Ultimately, it's junk. But these were definitely lines of credit that Mr. Champagne was aware about. It was before she filed the divorce, while we had the children. So to try to answer your question, it was used for marital funds to keep my house going, to keep the bills on, and part of it was to keep the children happily and entertained when I was at work.
Well, all right, thank you. But again, most lines of credit usually are secured by a mortgage. It's unusual. They have just open line of credit without
I don't know
any security. But the fact that it was in your name alone, Mr. Champagne, you should have raised that issue during the divorce proceedings to make it really clear that, no, that's not my debt alone. Even though it's in my name, it should be a marital debt, and we need to address it as part of the divorce settlement. So absent that, Mr. Champagne, it appears to be your responsibility. And the only reason that it got put on this property is because it was attached to the property was in your name. And then the judgment lien attached was recorded in September. You quit claimed it in December. So that lien was already attached at the time that you quit claimed it. So it should not have been responsibility of Ms. Champagne to pay that.
Well, that's not so, because when you say you don't have time, and that's what's aggravating me the most.
Mr. Champagne, this is a motion hearing. Do you want a trial date? I mean, this is a motion hearing. There's a lot of 15 minutes argument. I'm just trying to get to the point. Mr. Champagne, I'm just asking for an answer to a question. But go on. I'll let you. Do you want to talk? I'll give you till 10:30. Keep talking. Whatever. I'm trying to get to the relevant points, Mr. Champagne, so I can ask the relevant questions to make an intelligent decision. I have time for you, Mr. Champagne. So go ahead.
Yeah, I said yes. I'd like your time. If you can't give it to me today, I guess the trial is what we need, because I need you to understand what's going on, not what they want you to believe. So when you have time to read the case file and get your facts in order, and we can, right. I would love a trial.
All right, we'll get a trial date. I'll gonna represent yourself, Mr. Champagne. Nancy, can you bring up the file, please?
Yes, sir.
Okay, I'm just saying, you need to, and Ms. Rosekolviak, you should subpoena the documents from Directions Credit Union so we can find out the history of this loan.
Yep.
It appears initially on the surface to be that responsibility of Mr. Champagne. because it was in his name alone. He should have raised it to the attention of the Miss Champagne and her attorneys at the time of the divorce settlement. Okay. All right. How about September 19th?
How long?
Thursday?
No, we can't do that day.
September 26th.
I can make it work.
All right. In-person hearing, September 26th, 8:30 a.m.
How long did you set for it?
I'm sorry?
How long did you set for it?
Give Mr. Champagne all day, Mr. Champagne.
Thank you,
You
sir.
don't complain to this court that I'm not giving you time. This is a motion hearing this morning, Mr. Champagne. You'd be well advised to retain an attorney. I'm telling you, based upon the preliminary things that I've read, and I've read your 4-inch thick pleadings, and I've read Mr. Chappell's pleadings. It appears on the surface that it's your obligation. It was in your name alone. It was never addressed in the judgment of divorce.
I thought we were gonna handle this.
Other than the fact that the Monronah property, this debt should not have been placed on the Monronah property, but for your failure to pay that debt to Directions Credit Union. But what's that for in-person hearing on September 26th, 8:30 a.m. The court
about
will
my-
require that the parties exchange exhibit witness lists and file trial briefs. How much time do you think you need, Ms. Rosekolviak, to receive to exchange exhibit witness lists and trial briefs?
A week
10
before,
days?
a week before is fine.
All right. So the court will order that so exhibit witness lists and trial briefs and to be exchanged and provided a copy to the court on or before September 16th, 10 days before.
I was wondering when my counterclaim is gonna be discussed.
What was your counterclaim?
Well, you said you read it, so I mean, I'm doing them for over $100,000 emotional distress, just physical, mental distress. This never stops. I'm asking for reimbursement of all the attorney fees that I've had to pay to defend myself, over $32,000. I'm asking for
We'll
Mr.
address that and we'll hear all outstanding issues that have been pled to Mr. Champagne on September 26th at 8:30.
Okay, I just want to make sure we're all on the same page. So I can get prepared for that, Your Honor.
Ms. Kovac, you can respond to that, his counterclaim as well.
Yes, will do.
Anything further, Mr. Champagne?
No, thank you, sir. Your Honor.
Okay, all right, that'll conclude this matter. Court will mail out notice.
Besides, I'm about to be on 70% disability from the VA. So it's going to be even harder for me to make payments.
The money's coming from your dad, not you. You have 2 children that we had together, so you're responsible for their child support. I've paid for them since they were 4 and 7, so you owe that money.
But we also said that we would take care of college. So you want me to
No,
pay
there's-
both amounts, $100,000 plus the $70,000 arrearage, right?
That's your dad. He has an investment fund that he started when they were born.
It's the family, whoever the money comes from. It's a
But
trust.
Dad, and you're responsible for raising your children and paying.
So bottom line is, you're saying that, yes, you want to pocket the full amount of the arrearages for yourself, and on top of that, have my family pay for full amount of college. Is that what you're saying?